Hi, good afternoon if you're on the East Coast, and good morning if you're out west. And to our friends from Hawaii, a very good morning. God bless you. Thanks for getting up so early, and I hope you have a good cup of coffee in front of you. We are very pleased you're joining us for the recent court decisions in student disputes that you should know about. This is part of the higher education webinar series offered by Thompson Coburn. We are a law firm located based in St. Louis, but with offices all over the place in D.C. and L.A. and Chicago and spots like that. Before we get started, I want to take just a minute to walk through our housekeeping while folks are still jumping on. So, like all of our presentations, that are part of this webinar series, this one is CLE accredited, so if you are an attorney and you're looking to pick up CLE, hopefully you'll be able to do that. It is already, meaning the presentation, is already CLE accredited in California and Illinois for an hour, a general CLE credit, and in Missouri for 1.2 hours. You don't have to work quite as hard in Missouri for CLE credit, apparently. We award CLE based on attendance for the entire 60 minutes. So if you're here for CLE, make sure you're clocked in for the whole 60 minutes. And keep in mind, from time to time, there will be a little pop-up screen that you have to just click on to reflect your continued engagement. If you're outside of California, Illinois, and Missouri, you may still be able to get CLE. You'll just have to apply to pick that up. And if you need help, reach out to us, and we can try to give you a hand. Throughout the presentation, you'll see we have these little widgets at the bottom of the screen. There's a Q&A widget. As you would expect, that's for questions and answers. If you've got questions, just drop them in, and we're going to look to answer them all here at the end. We've allotted time to do that. A copy of today's slide deck is available in the resource widget, also down there on the widget panel, and we certainly encourage you to download the materials, which are there. You can also find additional answers to some common technical questions in the help widget. Finally, I'll just note, as I always do, there's a survey at the end, and if folks are willing to fill out the survey, we're very grateful. We always review those comments, and we have made changes and will make changes in the future. We want every presentation to be better than the one before. So I mentioned at the outset, Thompson Coburn, for those of you who may be new to us, is a pretty big law firm. We have about 400 attorneys these days with offices in multiple locations. We do a lot of different things, like a lot of big law firms, and among them we have a higher education practice, which is not like a lot of law firms, actually fairly unique. This is Lacey speaking right now. I lead the higher education practice and host this webinar series, but I'm very pleased and gratified to say that it is not me always speaking to you. We have a lot of other folks here who work with institutions of higher ed as part of the practice, and when I'm fortunate, other folks will actually take the lead and just allow me to host, and they'll actually be the presenters on these webinars. And today I have a couple of great friends and colleagues, Bill Bay and Jeff Fink, who actually appear here on the screen, that do a lot of litigation and agency type work, agency meaning the U.S. Department of Ed, accreditors, and others. I mentioned this is part of our higher education webinar series, so starting in the fall, usually with the beginning of the academic year and running through the end of the spring, we try every month to offer a CLE accredited webinar specific to higher education issues. By the way, they're all free and on demand, and after they're offered, we post them on our website, and you can go anytime and listen to them just by clicking. So here, when you get these slides, these are live links, and if you want to go back and listen to any of the prior webinars sort of at your convenience, you can just click on one of those links, and it'll take you right to it, and it'll pop up right there on your screen. You can also see, I'll just take a sec to note that we have another webinar coming up, and it's actually just in a couple of weeks. This one's at the end of February, next one's at the beginning of March, on immigration issues in higher ed, and our partner, Kelly Simon, will be taking the lead on that, who does a lot of immigration work, including for some large research universities, and particularly on the faculty side, and she'll be talking about some pretty interesting things in the immigration space, so please feel free to join us for that. I mentioned earlier today you've got two speakers leading the charge, Bill Bay and Jeff Fink. Bill has been in the litigation space for a very long time, has worked specifically in the post-secondary space and been working with institutions of higher ed for over a decade, indicates here in the first bullet, over 60 claims and lawsuits and arbitrations. Bill also, I don't know if he did list it at the bottom. I just want to note he's the past chair of the ABA section on litigation. and will soon be, we think, maybe the chair of the ABA House of Delegates, which is like the king of the ABA. Am I allowed to say that? Probably not. All right, so maybe. We'll see if folks make good decisions and vote like we want them to, right? Very experienced litigator. Another very experienced litigator, Jeff Fink, is sitting just to Bill's right here in the room, and also has decades of experience. And in addition to doing a lot of litigation with institutions of higher ed in the last 5 to 10 years, has done a lot of work with me and some of the other regulatory folks on program reviews in front of the U.S. Department of Ed, various types of investigations and appeals, and also done some work with various accreditors, dealing different kinds of accreditation actions, and if need be, heading on to federal court. So 2 gentlemen who've done a ton of work in the higher ed space. With all of that being said, I'm going to pitch it over finally to them. We got all the stuff cleared off the table here so they can really start the presentation. But the one thing, before I let it go, that I do want to mention, we thought, there's a lot of litigation coming through all the time that impacts institutions of higher ed in one way or another. Some of you are members of NACUA. I know if you follow their website where they're posting litigation and agency actions that have come through on a regular basis, which is great. If you haven't, you should check out NACUA.org. But it can be overwhelming because there is so much litigation, and some of it's impactful for higher ed, some of it's sort of tangentially related and may not be as impactful. And we thought it would be valuable to take a step back and try to curate some of that litigation that we've seen over the last few months and bring through this presentation to your attention some things that we thought were of particular note. Here's my request to you. If you like this idea of this type of presentation, let us know at the end. Drop a comment on the survey, because what we could do is add it as sort of a quarterly or biannual feature where we, again, sort of go through the litigation that's occurred in the last few months and try to highlight for folks the things that we think are of particular import. So when you get to the end, if you think, boy, this is really a useful exercise, please do jump on the survey and let us know. And so with all of that having been said, I will hand it over to Mr. Fink.
Good afternoon and good morning for those of you still in the morning hours. This is Jeff Fink, and as Aaron said, we have lots of decisions that affect institutions of higher education. In fact, every month there's literally dozens of decisions issued by state courts, federal courts, administrative agencies, and it seems like almost every area of law has some kind of impact on your schools. What we've done is look through some decisions the last 3, 4, 5 months, and today we're going to talk about 6 of them in 6 different areas that could have an impact on your school. We're going to first of all talk about 3 that involve lawsuits directly by students against schools. We're going to talk about a case involving DePaul University up in Chicago involving a claim of breach of contract for wrongful dismissal. Then we're going to move on to a case from Washington against a public school there. And we're going to talk about the interplay between student threats of violence and the First Amendment. This was a case that I thought was noteworthy and kind of caught me by surprise. And to the extent that you might think, well, if a student makes a threat against their school, we can kick them out right away. Well, as we'll see when we get to that case, that's not exactly true. And then after that, we're going to talk about a case involving student discipline and due process rights, a case where it seemed like the school had great grounds to get rid of the student, but you may have messed up by not going and following the due process rights of the student. So we're going to talk about those 3 cases first, when there are lawsuits by students directly against their schools, and then also the last few months came across 3 other cases I think will be of interest. They're not necessarily direct lawsuits by students against schools, but they touch upon that relationship between you and your students. We're going to talk about the recent decision came out of the Pennsylvania Supreme Court involving Penn State University and its former general counsel, and the hot water she got in when her school, Penn State, and 3 of the top school officials were called to testify before the grand jury in the Jerry Sandusky debacle. We'll talk about that. After that, we'll talk about a bankruptcy case. And you think, well, how does the bankruptcy case have any impact on us? Surprisingly, when we get to it, you'll see that just because you're getting money from a student's parents, you think, well, this is a great thing. I'm getting lots of money. I'm getting paid. Lo and behold, you may have to turn that money back over. And that came as a surprise to me, and I thought that might be of interest to you. And then lastly, We're going to talk about the recent ruling in the D.C. court about arbitration and the ever-changing arbitration rules that the Department of Education has been issuing. We have the rule from 2016, then we have a new rule, we have guidance in between, we have litigation, and schools have been torn back and forth as to what they can and cannot do in terms of using arbitration clauses with their students. So we'll touch upon that in our last case. And along the way, as we talk about each of these 6 cases, we'll discuss how they could impact your institution and what you can do to minimize your risks. So let's talk about our first case. This comes out of Chicago, the Windy City, and it involves a breach of contract claim for wrongful dismissal. And we talked before, typically in the past, and even decades ago, and even recently, schools typically were pretty immune from claims by students complaining that they weren't getting a good education or doing something wrong. There was something called the education malpractice doctrine, that students generally could not complain about the quality of your education. And the reason for that is the courts did not want to second guess. They didn't want to question the academic judgment, the academic decisions made by schools. The court said, we are judges. We are not educators. We don't know what's right or wrong in teaching students and in evaluating student performance. That's for the schools to do. We're not going to get involved with that. The past decade or so, students have found a little bit more receptive audience with the judges, and they're starting to be able to chip away at the education malpractice doctrine. They've been coming forward and saying there's been fraud committed or negligence or violation of our constitutional rights or a breach of contract. And this decision came out of Chicago late last year. I believe it was December of last year. Was kind of a novel decision. I mean, you can understand how the court reached the decision it did, but it seems to open a potential floodgate of litigation by students against their schools. And it could make it a lot easier for them to sue based on this theory they came up with called breach of implied contract. It's a theory that the student doesn't have to point to any enrollment agreement, any student handbook, any particular document to claim a breach of contract. Instead, the student is able to say, I had an implied contract that if I did everything right, I proceeded, that you, the school, would give me my degree. You would graduate me. You wouldn't dismiss. So
Yeah, and I'll just add, Jeff, we were talking about this. This is Aaron. When the U.S. Department of Ed went through its bar defense rulemaking in 2016, one of the bases that they permitted for a bar defense claim against an institution was breach of contract. And in the preamble to that final rule, which, if you have a bar defense claim on a loan issued prior to July 1, 2020, this standard's going to apply. And they said, the department in the preamble said, look, when we're talking about breach of contract, we're not just talking about an enrollment agreement at a for-profit institution or proprietary school, career school. We're talking about a breach of, and the department in the preamble was very explicit and said, could be your catalog, could be a bulletin, could be, and they sort of had this wide range of written documentation. And to your point, what the department seemed to be suggesting was, there's this contractual relationship, and that relationship isn't defined by a specific legal contract, as we would think sort of in the traditional sense, but really is all of those written representations and things that define the relationship between the student and the school.
That's correct, and the court decision effectively opens the door for students who have federal student loans to come back and say if they're not unhappy, they don't like they're having to pay back, to come back and allege that their school breached an implied contract, they did something wrong, so they can try to avoid their federal student loan. Let's talk about this case. And the common theme today, you'll notice, it seems like a lot of these cases involve students in nursing schools. I'm not sure why that is, but it just happens to be that way today. But anyway, let's talk about this case. This involves the North Shore University Health System in Chicago, which is affiliated with DePaul. And they had a student by the name of Bosch who was in a spinal clinical course as a nurse anesthetist. And he had done well, had passed everything before. He was in his last course, which is mostly clinicals, meaning he was on-site at healthcare facilities, learning how to be a nurse anesthetist, doing the things that a nurse would do so that when he graduates and gets his certification, he can go in and practice. But during that last course, for whatever reason, he either didn't do well or the faculty, the instructors didn't like him and ran him out. That's the dispute in the case. Student was put on probation, and then he was later dismissed from the program based on the evaluations and recommendations of these two clinical instructors. They claimed, and according to them, the student wasn't doing a good job. He was messing things up. He didn't have the right procedures in place. He wasn't maintaining cleanliness, and basically wasn't doing a good job as somebody who wanted to be a nurse anesthetist, which, if true, you think, well, this is very justified behavior by the instructors because you don't want somebody like this to be treating patients. The student, of course, had a different take on it. He said, no, I didn't do anything wrong. Look, I did well all these years getting up to this final course. During my final course, these instructors, for whatever reason, they had it out for me. And they were fabricating stuff. They were looking for any reason to get rid of me. So he claimed that they were manufacturing reasons to discipline him and get rid of him. And they were using false, arbitrary, and subjective reasons. They were basically lying about his performance, making up false accusations about him, and doing everything they could to run him out of the school and keep him from getting his degree. Now, you may ask, is that plausible? Well, you typically say, hopefully not. You assume your instructors are acting in good faith, but the student alleged it, and the court said, well, we're going to have to accept this as true for deciding it. And that's a big point on this decision. The court, and this came out, it's called a motion to dismiss stage in the case, which means that the court basically has to accept all the allegations as true and say, if these allegations are true and could be proven, would the student have a viable claim against the school? In this case, the court said, yeah. The court did caution, well, the student may have a hard time proving it, but you know what? The student has a right to do that. He's entitled to get discovery, and this may end up going to a trial at some point. In this case, the court said this is enough, what the student alleged to claim, state a claim for a breach of an implied contract. And this is interesting. An implied contract is not a written contract. He's not pointing to any piece of paper. What he's saying here, and this is what the court said, is there's an implied contract here and there's a breach. And all you got to show if you're the student is that you paid your tuition, that's every student. Secondly, the student has to show that they satisfactorily performed the coursework. That's an issue of dispute in the case. The student said, yeah, I did, but the instructor said, no, he didn't, but that's a disputed fact. The student said, I did everything right. And then the third thing that the student has to show is that the school wrongly dismissed him and denied him a degree or advancement toward a degree. So it's just a wrongful dismissal. Doesn't have to point to any piece of paper. All you have to do is go in and say, look, I did the coursework. I should have been graduated. I should have received my degree. The school denied me that for a wrongful reason.
So in 2016, then, the department was willing to cast a very broad net and say, we'll consider lots of different kinds of writing or documentation to represent a contract. But here, what we're really talking about is the court saying, you don't even need anything in writing.
No, actually, nothing in writing. The court does say it's helpful if you have stuff in writing, and the student can point to that to bolster the claim. But at the bottom, the student doesn't need any piece of paper at all to make this claim for breach of implied contract. And kind of the money quote from the decision is, the quote, a claim that the student fully performed her coursework and was denied a degree or is wrongly dismissed and prevented from progressing toward it is the beating heart of the implied contract between the school and the student. The school promises a degree if the student adequately performs her work. And you might think, well, isn't that the school's job to determine whether the student adequately performed the work? Typically, yes, but this court has left open this door for students to claim, hey, I did adequately perform, and the school wrongfully dismissed me. So that's kind of the million-dollar question that the court had to face is, okay, we have this deference to educators, so how do we define what is a wrongful dismissal or a denial of a degree? And the court stressed and reiterated, we're not going to second-guess academic decisions in the judgment by schools. So if a student got a bad grade, the court's typically not going to intervene and say that student deserved an A when you gave him a D. They're not going to check on the adequacy of the test. A lot of students will complain and say, oh, that's not fair. That wasn't on what I was taught in class, or that's not in the book. The court's probably not going to get involved with that. That's for the school to determine what should be tested on and how adequate the exams are. And they typically are not going to get involved with the quality of the student's work. Like I said, they're not there to second-guess the instructors, the teachers, as to how the student performed. Instead, this is per the court, school acts wrongly only if their academic decision is, quote, arbitrary and capricious or the product of bad faith or malice. It's a pretty broad standard, pretty vague, too, because it's pretty easy for a student to come in and just say, well, I did everything right. This is arbitrary and capricious. There's bad faith or malice. court clarified that you have a wrongful act only if the academic decision lacks any discernible rational basis, or if there's a substantial departure from accepted academic norms as to demonstrate that the person or committee responsible did not actually exercise professional judgment. And I think in the end, this is kind of troubling. The court said, really the question is the motive, intent, and sincerity of the clinical instructors and other supervisors and advisors. That's very difficult because, I mean, you may have a lot of objective factors. You say that, look, the student did not perform X, Y, and Z. They did not perform well in the class. They did these things wrong. They didn't submit the paperwork. They performed poorly on a test. But the court here is opening the door and saying, well, you know what? We're still going to look at the motive, intent, sincerity of the instructors, which is a very vague standard because, I mean, frankly, not every student is beloved by their teacher. And because they might be a pain, they just may not like them for one reason or another. And it's kind of opening the door to, do your teachers need to love all their students? Because if they don't, student who is not loved, is he going to come in and say, look, this teacher's got a bad motive. That's why they failed me. That's why they kicked me out of the program. Okay. So in this case, as we noted before, the court said, yes, the student has a viable claim for breach of the implied contract, but it was based entirely on what he alleged. And the court said, look, this may be a very difficult case for the student to prove. And the student's going to lose the case if the case boils down to whether the school personnel were correct or justified in their academic judgment. So what the court's trying to say, look, if it's all about a matter of academic judgment, we're not going to second-guess the school. But still, any school facing a claim for like this is likely going to have to go through full discovery and a trial to ultimately prevail. It's going to be very difficult to get a case like this dismissed early on. So all the student has to do is come in and say, yeah, I know the school gave me bad grades. I know the school said I did things wrong. But you know what? That was all fabricated. That was all wrong because my teachers had a bad motive. And I should not have been penalized for that bad motive. And because of that, when you get a case like that, it's easy to make allegations like that. Cases like this are probably going to go through discovery and trial before they can get resolved, which puts schools in a pickle because it costs a lot of money to respond and defend litigation like this. Now, there's some other interesting rulings made by the Illinois court. This is the Illinois Appellate Court in Chicago in this Bosch case. First, they said the student couldn't rely on accreditation standards applicable to the school. This is interesting because the student was saying, not only did you breach my implied contract, but you, the school, breached your accreditation standards with your accreditor. And because of that, that forms a contractual basis for me, the student, to sue the school. Basically saying that I have a contract with you, the school, that you, the school, are going to comply with your accreditation standards. The court rejected that argument and said, no, students can't rely on accreditation standards. And they kind of gave a couple reasons. One is that they say the relationship between the accrediting body and the student and the school is administrative, not contractual. And accrediting bodies usually, they impose their accreditation standards and they can change them at any time. So there's really no contractual basis with the accrediting body. It's more of a licensing entity. It's more like a quasi-governmental entity. And because of that, the student cannot go after a school for not complying with the accreditation standards. Another interesting ruling from the court, and this kind of ties to the breach of implied contract, where the student is allowed to, if he could find miscellaneous provisions and documents and handbooks, he could tie that into his claim to show the bad motive. In this case, the student was citing a portion of the student handbook that's talked about a quote, formative evaluation. And that provision in the handbook said that clinical instructors will give feedback that, quote, addresses deficiencies or areas needing improvement noted during case management. In this case, the student alleged that the instructors, they made no real attempt to provide feedback but trumped up phony charges. So, and the court said, well, that could be a part of the breach of contract. So if you've got a handbook out there saying that your instructors are going to provide, quote, formative evaluation or feedback, and they don't do it, or they don't do it in a way that meets the student's expectations, the student might come forward and say, yeah, you breached your contract. You didn't give me the feedback that I was promised in your school handbook. And then lastly, the court also said that the school couldn't defeat the student's lawsuit based on the internal grievance and appeal process that it had in place. We've talked about this in the past, that a lot of times one way that you could try to defeat student litigation against you was to have an internal grievance policy Because hopefully courts would look at that and say, students, before you come to court, you should really try to work your dispute out with the school. Go through the grievance policy. Try to work it without them. Don't come to us in the first instance. In this case, there is a grievance policy, but the court said, well, it might be there, but you know what? The student can come straight to court. Doesn't have to appeal it. And the reason they said that, it wasn't very clear in the policy. It didn't say in the policy that you, the student, are required to exhaust this appeal, this grievance process before you can go to court. So I think one lesson from this case, if nothing else you take from today, is that if you've got an internal appeal process, a grievance process in your student handbook that you're expecting students to follow, you ought to make it clear in there that the student agrees that they need to exhaust that fully, pursue all their administrative remedies that you're offering before they can go to court or sue you or do anything like that.
This is Aaron. I just want to, Bill and Jeff spent a lot of time working with schools to help them get out of issues when things go sideways and they end up in litigation. I spent a lot of time working with folks on the front end to try to design these handbooks and policies in ways that make sense. And I think there are a couple of really important themes here that it's worth saying go well beyond this case, that we're seeing reflected in the regulatory community among legislators. I mean, the first is this idea that there are a lot of regulatory bodies now, including the U.S. Department of Ed and others, that do not like the idea of forcing students to go through an internal process before allowing them access to courts or direct access to the department and an ombudsman or an accreditor or whoever. So, just thematically, I think schools have got to be prepared for this idea that courts and other regulators and administrative bodies are moving in a direction where they are not going to just send a student back to the school, in part because there are concerns about whether or not the student can even get a fair shake, right? I mean, if they're in a dispute. The second theme I think that's really important to understand is that increasingly regulators and courts are willing to point to documents that aren't formal contracts and say, yeah, that's a contract. And years ago, I remember doing research 15 years ago, and there were very few jurisdictions where someone had successfulully argued that, say, a catalog was a contract. That is changing, and it's not just here. We're seeing that increasingly in more and more cases and among the regulators in the Title IX context and others where courts are willing to say, look, if you've got a catalog that spells out a process, for example, for disciplinary proceedings, you've got to follow that process. And if you fail to do so, then you haven't followed your policy. You haven't accorded all the process to the student or employee that you said you would. The last thing I want to hit on is an idea of technical standards, and that usually is discussed in the context of the ADA and disability matters. But I think it's relevant here. And if you Google technical standards nursing school or technical standards medical school, and those of you who have nursing and medical schools will know, they all have them, right? And the idea is you, for all of your students, lay out for each program a set of, quote, technical standards, and this idea, there's a lot of jurisprudence around it now, that says, look, if you're going to be a student in our institution and you're going to enroll here, you're going to have to be able to do these physical things, and you're also going to have to meet certain behavioral and professional standards. Courts have said, yes, schools can articulate, that there are certain things that have to be done, whether you have a disability or not. Now, if you do have a disability, then we'll talk about accommodation. But at the end of the day, everyone has to be able to satisfy these technical standards. I think that becomes increasingly relevant in the context of a case like this because, if you're in front of a court and a student's saying, they kicked me out because they just didn't like me, it's going to be important to say, actually, we have a list of 25 different things that we say every student has to be able to do to be admitted to and stay admitted and successfully progressing through our program. And they include these various physical, behavioral, and professional standards. And then there are these really concrete ideas that a school can point to, not just, otherwise you have instructors saying, well, they just weren't being very good in class, or but now you've got this list of standards. And you can say, look, one of our standards is you have to show up, and every day you have to interact in a respectful and meaningful way with your colleagues and your professors and the administrators here. And then you provide factual evidence and, affidavits and witnesses who show that standard wasn't met. But I've long been an advocate, and I will take up a little time here just to say, I don't care what your program is, and it's not just about disabilities. It's not nursing programs, but any program you're offering, you ought to have technical standards. You ought to give them to every student at the time that they are getting ready to enroll and have them sign a disclosure saying they understand that they have to satisfy those standards. And then if things go south down the road, you've got this, articulated set of standards that you can present to a court that serve as a backstop. And then it's just a matter of showing that from a factual standpoint and a reasonable standpoint, the student failed to satisfy those standards.
Thank you, and that's an excellent point. That segues into our, what can schools do to prevent or minimize their risk of liability for claims of breach of implied contract. And Aaron's point is excellent. The first thing is you ought to have the expectations made clear to the students up front, in writing, preferably acknowledged by the student, so that they can't come back and say, well, I never knew I needed to do X, Y, and Z to pass the class and get my degree. The expectations need to be made clear to the student at the outset. But other ways steps you can take to minimize your risk is make sure you have adequate document email retention policies. These claims by students may not come right away. They may come a year, 2 years, 3 years down the road. Statute of limitations in many states is very long. Here in Missouri, you could go up to 5 years before you face a lawsuit where a student comes in. So you want to make sure that you've adequately documented and kept your emails as to your students. And definitely be on the lookout for students who you think could pose a problem for you, who are the complainers, who are potential future plaintiffs against you. If you have a student whose performance is deficient, I make sure you document it. You don't want to have to rely on instructors' memories months or years down the road as to how good the student was doing. Make sure that the student's performance is well documented, and then make sure that documentation is kept. If a student complains, that's a warning sign that the student might be on the verge of filing a lawsuit down the road. You get a student complaint, thoroughly investigate it, and again, document it. You've got hundreds, if not thousands, of students. No one's going to remember everybody. Instructors aren't going to remember all their students. But if you have documentation of everything involving students who appear to be troublesome, that'll help you down the road. And then before you dismiss a student, I would double check and make sure you've dotted all your I's and crossed all your T's. Make sure that your dismissal is consistent with and justified under your academic policies. Make sure that it's not arbitrary or capricious, and make sure it's not the product of bad faith or malice by the instructors or school officials. That's hard. I appreciate that. I mean, you don't know what motivates a lot of instructors or school officials. I think it doesn't hurt to ask the instructors who are involved at the time of the dismissal, who are giving you the recommendations. Talk to them. Make sure that their reasoning for wanting the student to be disciplined or removed from the school, that it really is legitimate and not something that's arbitrary or bad faith.
Yeah, I think that's a key point. Don't be afraid to ask hard questions of the people, okay? Ask the hard questions. Why are we doing this? Go through it again. Make sure you're looking at pieces of paper where, that somebody may have put things in instructor comments or otherwise that really suggest something different. You want to ask those. You want to get them resolved. You want to get explanation early. And I think that's, that's the double check of the dismissals. Make sure you've asked the tough questions and do these items.
Yeah. I mean, the fact is, we all know sometimes instructors just don't like students, right? I mean, that possibility is always at least out there on the table. So before you go too far down the road, it'd be good to know just what you're dealing with. And I know the general counsels and compliance folks on this call, certainly in hearing that kind of advice, we know that is hard. And it's hard to do. You got a lot of squirrely, sometimes faculty and staff that you're dealing with. And at a large institution, you may have a number of dismissals every month, right? But it is a fact that students are getting more play in courts these days. And for a lot of different reasons, we think the trend is going to continue to be students getting more opportunity and to bring actions if they're litigious, and courts listening a little more intently to what they have to say. And all of that is part of, college costs and all that conversation, and sort of the sense that this is a significant financial investment, and et cetera, et cetera. But it's coming, if not already here, and it's worth, to the extent you can, putting in that extra time.
And part of this is really just doing the right thing, making sure you're doing the right thing, and sometimes it's explain to somebody who isn't, because eventually jurors and judges aren't in the field of education, explaining the issue, explaining what happened. And if it can't be explained, or it's too complicated, or it seems unfair to people that are outside the education area, that's something you got to confront early.
All right, let's talk to our next case. Case number 2 for today we're going to talk about involves the interplay between student threats of violence and the First Amendment. It's kind of a timely topic in recent years. We've had threats of violent acts by students seemingly become more common in recent years, and a lot of these threats of student violence and their acts are really at the college level. I mean, we had some stuff still at the high school level, but I think more and more it's really occurring at the college and university level. We've had numerous incidents of school shootings, and I mean, that's put people on edge. But notwithstanding that, and I don't know if the courts just aren't catching up with reality here, not all the time can you, especially as a public university or college, get rid of a student for basically threatening violent acts. And this recent decision out of the Eastern District of Washington State provides a good example. It was a case by a student against Columbia Basin College. In that case, the court ruled that the college violated the student's First Amendment rights by barring him from campus after he told his doctor and his mental health counselor that he had homicidal thoughts as to 3 instructors. He's basically saying, I want to kill my instructors. This student was also in the college's nursing program, and he was down to needing to complete 1 more quarter of classes, just like the plaintiff in our last case. He told his doctor and a mental health instructor he had homicidal thoughts about 3 of the instructors, and the reason is because he had gotten some bad grades and feedback from them. And not only did he have homicidal thoughts, he expressed exactly how he thought about killing them. He said, I was thinking about killing them by lighting their offices on fire, attacking them with saws. And because of these thoughts that were being expressed, the mental health counselor thought they were serious enough. She felt obligated under the state's mandatory reporter law to warn the college about the student's homicidal thoughts. And you think, well, that's something to be commended. How do you know if the student is going to act upon these thoughts, these bad thoughts? So the counselor warned the college about it. So after that, the college investigated. It did the right thing. It didn't just kick him out right away either, which I think is an important point. It obtained the student's medical records, and it talked to the instructors. And not surprisingly, the instructors were afraid. They said, I don't want this guy attending classes, and I don't want him on campus anymore because I'm afraid he's going to kill me. And if you were the instructor in their shoes and you heard that, I think that's a very justifiable reaction. So ultimately, after doing a fairly thorough investigation, the college banned the student from attending classes. But it wasn't for good. I think they were empathetic, and they said, look, you can re-enroll after several months have passed, and you've participated in mental health counseling, and you've passed a mental health evaluation. To me, that seemed to be a rather reasonable solution. But the court disagreed. The student disagreed, obviously, and ultimately the court disagreed. The student sued, and not only did he sue the college, he sued the assistant dean of student conduct. He was the one who led the investigation, and he sued the college's president, because the president considered and denied the student's appeal. The student claimed a violation of his rights under the First Amendment and the Americans with Disabilities Act. And this was what was interesting. It wasn't after trial and after the evidence. The court ruled as a matter of law on summary judgment, no trial. They said, you, the college, have violated, and the school officials, you have violated this student's First Amendment rights. It's kind of interesting, this distinction to try to make between institutions of higher education and primary and secondary schools. Primary and secondary schools, the courts have been pretty clear that if there is an off-campus threat or violence at the school, schools can intervene, take action, and discipline the student, keep them out of the school if there's some kind of threat that occurs off campus. But for whatever reason, the court here, and this court's not alone in this, mind you. There are other courts throughout the country who have kind of come and same the view, and I think they're struggling through this body of First Amendment law, because they're saying this body of law that we're going to protect schools really only provides in the primary and secondary arena. Things are different in colleges, because students in colleges and universities are not children. They're adults. So therefore, they have stronger First Amendment rights, and we've got stronger protections for college students than we do for high school students or elementary students. In my view, that's kind of a strange distinction, because I would think that threats of violence at a school should be treated the same, whether it's the primary, secondary, or post-secondary levels. But the court, struggling through these issues based on existing law, says, well, no, that's not the law. There is this distinction, and we've got stronger First Amendment rights for college students. Even so, then, we got around that issue. The court said, okay, the real issue here is this doctrine called the True Threats Doctrine. Under the True Threats Doctrine, the Supreme Court decided this many, many years ago. True threats are not protected speech. And what is a true threat? Well, a true threat are statements where the speaker means to communicate a serious expression of an intent or commit an act of unlawful violence to a particular individual or group of individuals. If the speaker targets specific individuals, the courts are more likely to find that the speech is a true threat. And if it's a true threat, then it's not protected. A couple important points. The threat doesn't have to be directly made to the target of the threat. It could be communicated to someone else and then learned by the target through a third party. So if the threat is communicated to, in this situation, I would have thought the threat was communicated to the student's doctor, the mental health counselor. I would have thought that would suffice as a true threat. And the court said here, the purpose of the true threat doctrine is to protect people from the fear of violence and the disruption that fear engenders. These three clinical instructors seem to have had a legitimate fear of violence from this, but in the end, the court said that wasn't going to suffice. And the reason the court said these aren't true threats, they gave three reasons. First of all, he said the student was discussing his homicidal thoughts with the doctor and with the counselor and did not communicate them directly to the instructors. So I thought that's kind of odd because the court also said that it doesn't have to be communicated directly to the targets. It can be communicated through others and then get back to the targets. The court didn't really give an explanation of that. And then basically in the end, the student said, well, I really didn't mean to do anything. And the court bought into that and said, well, the student said he really didn't mean anything, so these aren't really true threats. So the college was kind of put in a pickle here. The student expressed, I want to kill these instructors. Those threats were communicated to the college informed the instructors, and you think you would take those threats at face value, but the court said, no, you can't take them at face value because the student is telling us now that he never really meant to do anything. He was never going to act on the threats. And because the court found that there were no true threats, both the college, and this is important, the school officials too, individually, were found to have violated the student's First Amendment rights. They just couldn't do it, and they couldn't kick them off campus. They couldn't even basically tell them to leave for a few months, get some help, and then come back. That in itself was a First Amendment violation. So as I see this true threats doctrine is interpreted by this court, and I have to say interpreted by other courts too, it puts public schools in a difficult position. How do you balance the safety of your teachers, your school officials, and your other students versus the free speech rights of a student who may be mentally unbalanced, having difficulties, and is threatening to kill or injure people? I think the best thing you can do in this situation, and this is what Columbia Basin College tried to do, is you need to perform a thorough investigation before imposing permanent discipline for threats of violence. You got to make sure the threats qualify as true threats, and you might want to even consider lesser forms of discipline. In this case, it maybe you interview the student, you talk to them, and try to work things out and see what's going on. Important point here too, though, is this First Amendment issue really only affects public schools because private schools are not subject to the First Amendment, so they have more freedom to discipline students for making threats like in this situation. But even that situation, though, if you're a private school, you should still make sure that what you're doing, your form of discipline, is consistent with your school's published policies. From what I've seen in my practice, most schools out there have in their behavior policies, obviously prohibitions against students making threats. I mean, that's pretty common. It should be a part of really any school's academic and disciplinary policies. But just make sure that if it's in there, that you're following that policy before you discipline a student for making threats against instructors or your students.
Yeah. And this is Aaron. I mean, I'll just add, and I suspect a lot of the folks on the line already know this, but look, I would prefer every day of the week to deal with litigation than a shooting spree on my campus. So, when the rubber hits the road, if you're on site and you think there's actually a serious threat or, to the safety of your student body, you got to do what you think is right. I wouldn't sit in a room and try to decide whether or not to send somebody home because you're trying to interpret your threats doctrine. You just have to appreciate that if you're a public institution and you make that call, after the fact, you could deal with a lawsuit, and you may have to wade through all the sort of academic and philosophical and legal questions that are being thrown up on the board by Jeff here. But, don't let these things, I always tell my clients when faced with something like this, don't let policy questions or legal questions get in the way of good, sound common sense.
Being practical and doing the right thing.
Yeah, you got to be practical and do the right thing. You got to, I'll also say I think this is a little out of step with the general attitude right now in the public and among legislators and regulators, with all the legislation, Clery Act and Title IX and all the state level legislation that's aimed at ensuring that campuses are secure and as safe as they can be, in some cases probably going, at least for many administrators, I think they would think a little too far and all the burden they're placing on institutions, and then you have a decision like this. But that's the natural tension, right, between the First Amendment and these type of safety, security, and all this, and it always has been for decades and decades.
Right, schools are struggling with it, so are the courts.
Yep, and they will continue because you got competing interests, right? And that's not going to go away.
All right, talk student discipline and due process rights. Nothing going on there. Kind of a little bit of a background, then we'll talk about a case out of Pennsylvania. I mean, obviously, schools typically have codes of student conduct and procedures for handling violations. It's a matter of due process in public schools, contract law at private schools. As we frequently talk to schools, I mean, the number one thing is have a good policy, and number two, as Aaron often says, then follow the policy. Follow the policy. That's real critical. But having said all that, students can bring claims against schools if they fail to comply with their policies. That seems obvious. We don't investigate the facts adequately. That's a problem. If you don't provide adequate notice, meaningful opportunity for a student to respond and be heard, you have a biased decision maker or do inconsistent decisions among really similarly situated students, and all of these are becoming kind of big issues. The case that I thought was pretty interesting here was a case out of the federal court in Pennsylvania just a week ago. Really an example of how a school might have solid reasons for dismissing a student that gets into trouble for not complying with due process procedures. So the student disputed the merits. Actually, it's more interesting than this. According to the court opinion, there were multiple challenges brought in the courts by this student pro se. He was admitted on a probationary basis to school. Then he disputed the merits of his poor grades. He was dismissed from the program due to his continuing shortfall in grades. He made numerous student record requests to the university, refused to leave the registrar's office when he was unhappy with the university's response. He was issued and violated numerous no trespass orders. The police were called out a couple times to arrest him. At one point, the judge opens his opinion by suggesting the student violated the law and manifesting his disappointment. Yeah, that's obvious. Another court convicted this student of defiant trespass on the university property, and a 1-year prison sentence was imposed. And the issue here is the school had suspended the student without a pre-deprivation hearing. I mean, on these facts, you got to think you're okay. It seems to be a student out of control. But despite all that, the student sued. The court held the student deserved a level of due process before being dismissed. Why? Because the student had a property interest protected by procedural due process in the continuation of his study under Pennsylvania law. So even though he was convicted of trespass, there was no demonstrable danger to persons or property justifying removing him without having a hearing. So that gives you a summary of what the court found the university's officials violated his due process rights, that even under these circumstances, the school has to give him notice of the charges against him, an explanation of the evidence, and an opportunity to present his side. The school said, wait a second, he's a continuing danger to persons or property. It's a threat to disrupting the academic process. You'd think that the trespass charge and the conviction would satisfy that. The court said no on that one. Rejected the university argument that it could suspend the student without a pre-suspension hearing, and the words are defying a no trespass order without accompanying threatening behavior does not make the student dangerous enough to lose his property interest in a pre-removal hearing. Fairly frustrating if you're the university. It also indicated that the university was at fault for not notifying the student about the date of the hearing and about the charges. So, where do we leave on a case like this? What can we do? I think there's a couple of things. First of all, the case is only at a motion to dismiss stage, so the court's got to accept his pro se allegations as true. The university may have ultimately prevailed on summary judgment or trial once all the facts come out. This has just happened a week ago. But it does provide a real careful example of the the thing I talked about to begin with. Have a good policy and then follow it. Use the pre-disciplinary hearings instead of post-disciplinary hearings unless safety is an issue. If safety is an issue, it's important to document it. Spend some time documenting the safety issues and what's there. And then if it is immediately, at least have the hearing a little later. In this case, it waited 8 months instead of 10 days. That was really the problem. If it had been, I suspect this might have been a little different if it had been a little sooner, but it wasn't. So that's kind of the issue with student discipline. Again, some old, some new, but again, it reflects a struggle that some of the courts are having about what to do in this area, about injecting themselves into it. All right, now we kind of move into the last three items. This one, can a school council represent both the school and its officials? And we kind of get into the Penn State matter. There's a lot in the Penn State example to talk about. We're focused on really just one of them today, which is a conflict between the school and its employees. So joint representation is where both schools and their officials are often parties in civil or criminal proceedings. The same attorney can sometimes represent the school and its officials, but it can pose some real problems, and that's what this particular case is about. The Pennsylvania Supreme Court ruled that the former general counsel of Penn State University, who was a former member of the Pennsylvania Supreme Court, acted improperly by jointly representing the university and the top three administrators in grand jury proceedings concerning the Jerry Sandusky case. And I know you all remember this because it was in the news for months. So the grand jury was investigating child abuse allegations against Sandusky. The university was subpoenaed for documents, and then the three individuals were subpoenaed. So the general counsel told the three employees she was representing the school. She told them there was no privilege. She didn't address the possibility of conflicts between them, but then she sat in on the grand jury as if she was representing them. And that really is the source of, I think, her big problem is she interviewed the officials. She did all these acts. She did some things right, but there were other things she did not do right. Really the principal one, I think, was sitting in the grand jury room without saying, hey, I'm not really your lawyer. I'm the lawyer for the school. And so that got her into a lot of trouble. The three school officials, it got much worse because eventually she was called to testify, and she began to testify about what they told her. I mean, it's like a nightmare for lawyers, but it's a nightmare for the school. They were then charged, and then later on they pled guilty or were convicted. Some of the charges were thrown out because they didn't have adequate counsel. So it really was, as you can imagine, continuing problems in the Penn State situation. The disciplinary proceedings were brought against the council and found that she violated several ethical rules, which is having a conflict of interest in representing both the university and the three school officials. While she denied doing it, the court, because she sat in the grand jury and because she did not say, hey, I'm not their lawyer individually, they found that it was a pretty easy case for them, at least. She failed to provide competent representation of school officials because she had no criminal law experience and never represented clients before a grand jury. She also did a very limited investigation of the university's extensive documents and emails. A couple of witnesses told her, well, I don't think I've kept any of this, and then never asked him to go back and look. And, of course, the guy had everything. So, and then eventually she breached her duty of confidentiality to the school officials by divulging their communications. The school said, hey, we're waiving the privilege. You can testify whatever. Court said, hey, that's great for Penn State, but it isn't great for these people. So they really got themselves into a real pickle on this one. And I think this is a lot of things that schools can do, and these are listed here. But I think part of this is kind of taking a look at what kind of proceeding is involved. If somebody is complaining about the school and its officials or employees, that's the situation most of you are facing. You're going to have an internal investigation. You're going to talk to employees. I would think even at that point, take a moment, make sure you understand the facts, determine who you represent, and then identify the issue that's the core in this case. When you're doing an internal investigation, you represent the school. Whether you're a lawyer or somebody else, you're representing the school. You'll represent the employee. What employees tell you is privileged for the school, but not for the employee. And if they ask the question, that means you can tell his or her superiors. I mean, that's the bottom line of it. Now, that's different from a civil lawsuit or a criminal lawsuit. In some civil lawsuits, you got to be careful because they're going to sue the school and the individuals. And if they sue both, you want to insist your outside counsel document that that he or she is representing the school and the individual. And you got to make sure your insurance company's on board, if that's applicable, and then get a copy of the lawyer from outside counsel so you got it, so it says exactly what you want it to say. Now, if there's a criminal case or a grand jury case, or if there's a grand jury subpoena comes to the school, this is at the risk of going full boomer on you. This is like the old Lost in Space classic where the robot constantly says at the end of every episode, "Warning, Will Robinson, danger, danger." This is what the general counsel of Penn State didn't see coming, and they should have. You first of all find out if the school is a target, if the employee is a target. If they're just asking for documents, that's one thing, okay? You can turn over the documents. But if somebody's being called to testify, you got to step back and make sure you understand all the possibilities. And as known here, if you don't have the experience in criminal law as a lawyer or in-house, if you don't have in-house lawyers, you need to get with a lawyer who has experience, not just in criminal law, but in these kind of proceedings, to make sure there's not some problem that you're overlooking and that can be easily overlooked. This is a highly specialized area if there's a grand jury proceeding.
So Jeff is going to summarize. We know we've got about 4 minutes. He's going to summarize the last two cases at a high level, and then you guys can look at the slides in a little more detail. The one thing I'll just add to what Bill said is, it is complicated, particularly as institutions become more complex and they have members. If you're a faith-based institution, you could have a university system above you. You could have a church. A lot of schools, larger ones, now have affiliates. They may have subsidiaries and foundations. And, it's easy for us, sort of hindsight's 20/20, to look at that case and think, boy, how do you make those mistakes? But it's deceptively complex when you've got big, complicated organizations with lots of constituents. And affiliates, subs, et cetera. So
it's a warning. I mean, here's a former member of the Pennsylvania Supreme Court, experienced lawyer, never had anything go wrong in their entire life, a long career, illustrious career, and yet the Supreme Court said, no, this is wrong here. And so that shows you there's lots of pitfalls. And what you got to do is, at the beginning, when there's a warning sign, grand jury, that's a warning sign. Okay, stop right there. Civil cases, make sure you're documented. Internal investigations, a little easier. You guys are familiar with those. But still, you got to always have your antenna up.
So, Jeff, officially, you've got 2 minutes. Take the time you need, and we'll stick around and make sure. I think there are at least a couple of questions that have come in, and we'll answer those even if we go past the top of the hour.
Very good. Our next case involves a bankruptcy issue, and in the end, there's probably not a whole lot you can do about it, but I thought it might be of interest to you. And it involves when you have parents of students, they're making payments or paying the tuition for their child. Very common occurrence. And you may not have encountered this yet, but you as a school might be liable to return the payment you got from the parents if they eventually file for bankruptcy. There's a provision of the bankruptcy code, it's in section 548, that says that the trustee, and the trustee is somebody who represents the bankruptcy estate of the parents. So when the parents file for bankruptcy, their assets and everything are put into a trust, and this trustee tries to administer them and make sure that the creditors get paid fairly. But in that situation, the trustee can recover a payment made by a bankrupt party, in this case the parents, when the party was insolvent if the party did not receive, quote, reasonably equivalent value from the payee. So if the payee, that being you, the school, did not provide reasonably equivalent value to the parents, then you might have to return the payment you got from the parents for the tuition payment. Now, there is a 2-year time limit, so that's still pretty broad, though. And how much tuition is nowadays, that can be a fairly hefty sum. So let's look quickly at this Palladino case out of the Federal Court of Appeals in Boston. This case involved Sacred Heart University, which unfortunately was required to refund over $66,000 in tuition payments received from the student's parents during the 2-year period before they filed for bankruptcy. The student was only 18 years old when she started at the university. Pretty common for a freshman. The parents were insolvent when they were making these tuition payments on her behalf. I mean, shortly after the student started, they were involved in a Ponzi scheme, and they're probably insolvent at the time. They were taking money from others, stealing from others, and making tuition payments for their daughter. Of course, the university had no idea the parents are involved in criminal activity or they're insolvent. So from the university's perspective is, hey, there's nothing out of the ordinary here. Parents paying me the tuition. A lot of parents pay for their kids. The issue in this case is whether the parents received, quote, reasonably equivalent value from the university for their tuition payments. And the federal court said no. And the reason why is the parents have no legal obligation to pay for college tuition for their adult children. And the university said, well, come on. There's a societal expectation. Parents are expected to pay for their kids' tuition. They'll be shunned. They'll be looked down upon if they don't. And court said, no, that doesn't cut it. They're adults. You're paying money out on their behalf. You're not obligated to do so. The parents, are really not getting any value for that. And I imagine some parents think that oftentimes when their kids drop out of school and don't finish their degrees. In any event, the university had to turn over $66,000 to the bankruptcy estate. Now, I have to say that this is not a uniform decision. Other courts have come to the opposite conclusion and ruled that schools were not required to return tuition payments from insolvent parents. I imagine a lot of times in those cases it's more kind of like, hey, the school didn't do anything wrong. I'm not making them cough up the money that they've already used and already spent to educate these kids. So what can you do? Virtually nothing. Not much you can do. And in fact, you're happy to usually get the parents to pay tuition because it helps you, especially if you're a for-profit school, it helps you in your 90-10 calculation. You don't have to worry about returning the funds to the Department of Education like you would a federal student loan or a Pell Grant. But in the end, there's no really a practical way to know whether parents are insolvent or going to file for bankruptcy. So you just have to realize that's just a risk of doing business, that you might ultimately get stiffed by the parents. And the last thing we'll talk about just very briefly is arbitration of student disputes. There was a decision that came out of the federal court in Washington, D.C., about a month ago, finally resolving one of the challenges to the 2016 borrower defense regulation. That just shows you how quickly justice progresses in the courts. Here we have a rule from 2016 that took effect July 1, 2017, and 2.5 years later, we're finally getting a decision about its merits. We talked in the past about the Federal Arbitration Act and how many schools, especially for profit schools, will use arbitration clauses requiring students to arbitrate any pre-disputes or any disputes with the school. Typically, that under the FAA, those agreements are enforceable. Students are required to arbitrate. In 2016, the Department of Education issued an anti-arbitration rule, which basically said that if you want to receive federal Title IV money, if you want to participate in federal aid programs, you can't use pre-dispute arbitration agreements. You can't use class action waivers, at least as to what's called a borrower defense claim, which is basically any claim that involves education where the student had borrowed money from the federal government to pay for their education. And so basically the government tried to say, no, we want to get rid of arbitration. We don't like it. We want students to be able to go to court. We want them to be able to go and file class actions. The 2016 rule was scheduled to take effect on July 1, 2017. Then President Trump got elected. New administration didn't like the old rule, that 2016 rule, so they tried to stay it. And then it took a year and a half later, and the federal court said, no, it couldn't stay it. So the 2016 rule is in effect. So after that, you had in a guidance from the Department of Education about a year ago in March of last year and said, well, now you got to comply with it. And it gave the guidance, told you how you could comply with it. Basically, it said you can't have new pre-dispute arbitration agreements or class action waivers as to borrower defense claims. And if you have an existing arbitration agreement, you've got to notify students that you're not going to enforce it, at least as to borrower defense claims. That's the state of the rule now. But in September of last year, the Department of Education, under the current administration, wants to get rid of the 2016 rule, get rid of the ban on pre-dispute arbitration agreements and class action waivers. They've issued a new rule. And it says now you can continue to use arbitration agreements. You just got to provide some disclosures on your website and during entrance counseling. So you just provide a little bit more notice. Problem is, the 2019 rule doesn't take effect until July 1 of this year. While the 2016 rule is still in effect, there was a challenge to it. There were good arguments, I thought, made. It was by an association of schools out of California. They challenged it, said this violates the Federal Arbitration Act. Department of Education has no authority to ban arbitration. Ultimately, the federal court, district court in D.C., upheld the ban. That was just at the end of January of this year. The court said the Department of Education has authority to do it because basically it can impose about anything it wants as a condition of participation in federal student aid programs. The court rejected the association's argument that the FAA precluded the ban. So where are we now with this? The 2019 rule takes effect July 1 of 2020. So at that point going forward, you can go back to using arbitration agreements, class action waivers, as to any type of claims. And you can do so and still participate in federal student aid programs. However, there's likely to be legal challenges to the 2019 rule. Every rule that gets promulgated by the Department of Education is challenged by one side or the other. And it takes years for these regulations the challenges to them to be resolved. Assuming the 2019 rule is valid, it's unclear what you can do at the time period before then. Can you enforce your arbitration agreements that are out there now, or do you have to hold off on them? I think in the end, it's unclear what the Department of Education is going to do. If you try to enforce those now, I think you could run afoul of the department. I mean, technically, you're not supposed to up until now. It's unclear whether this current administration would enforce it. And if you're out there trying to enforce your arbitration agreements now, will the department kick you out of the Title IV program? I don't know. Hard to say. They seem to be fairly sympathetic to schools on that point. However, you don't know what's going to happen in the 2020 election or down the road. If you get a different administration with a different position, conceivably they could come back after you and say, well, you know what, there was this period of time when you weren't supposed to enforce your arbitration agreement, you didn't comply, we're going to kick you out of Title IV. So I think absent further guidance from the department, the safer course is to continue to comply with the 2016 rule and do not use or try to enforce your arbitration agreements and class action waivers that were entered before the new rule takes effect in July of this year.
And I'll offer just a couple of additional points. I mean, one is when the 2016 rule was promulgated, I know that we tend to think about this rule primarily in the context of enrollment agreements used by proprietary schools, but it is worth noting that the language of the 2016 rule does not limit its application to enrollment agreements. It just says you can't use pre-dispute arbitration waivers and class action waivers in agreements with students. And, you know, my gut is there are a lot of traditional institutions of higher ed that may have other agreements with students that include arbitration provisions. I don't know, to use the gym, to park in the local parking garage on the back of the ticket. And it will be interesting to see if any of those are ever challenged or someone ever attempts to suggest that it violates this rule. Now, this administration actually, in renegotiating the bar defense rule, acknowledged that it really was not their intent. The idea was not that this particular provision would get that far, and it was more focused on enrollment agreements. But that's not in the commentary or the language of the 2016 rule. The other point I'll just make is the Democrats in the House, as some may be aware, are already trying under Congressional Review Act movement legislation utilizing the Congressional Review Act to kill the 2019 bar defense rule. So that's this administration's effort at that rule. That it is highly unlikely that will go anywhere. The only way I think a CRA effort is successful is if one party owns both chambers and the White House. But if on the other side of November, or I should say the other side of next January, you were to see the Democrats control the House, the Senate, and White House, I think it's very likely that this 2019 rule, they could re-up an effort to kill it using the Congressional Review Act. And because it doesn't become effective until July 1 of this year, it may be fair game for that type of attack. So, and even if it's not, I think, Jeff, you're absolutely right that we're going to see efforts to kill it or regulate it out of existence. We may see yet another round of bar defense regulation. As the folks who listen to us regularly know, we follow all of that extremely closely, and I'm sure that you will hear if there are further iterations that we'll do. We'll cover those in webinars and presentations. Similarly, we're all waiting right now for this final Title IX rule to drop, and as soon as that happens, we'll almost certainly have a timely webinar about it. So with all of that, we do have a couple of questions here, and for those who are willing to can extend a little past the hour, we'll look at those. I also just want to mention, you know, we have our webinars are on demand. They're really easy to get to. That's what the page looks like where they're all housed. And I should note that our firm does other webinars, too, that are available there outside of higher ed formally. Actually, I'll go back and just a great example. You see right next to where it says higher ed and immigration, using GDPR to prepare for CCPA and vice versa. So that's not part of our higher ed series. It wasn't specific to higher ed, but certainly many of you are aware of and interested in the impact GDPR and CCPA may have on your institutions. All of these are available on demand, so please feel free to check them out. Regulation is our blog that where we periodically write about federal regulation policy, state regulation policy. Please feel free to check it out or subscribe. And we do occasionally put out documentation guides or white papers on various topics. We had a reporting guide we did on the bar defense rule a little while back, and for those of you who are NACUA members, you may have seen we just had a NACUA note, actually, that came along that also dealt with financial responsibility reporting under bar defense. So, you know, we make these resources available as part of our commitment to the community. We hope you know they're out there, and please take advantage of them if you're interested. That's why they're there, and we're happy for you to do so. All right, with all of that being said, let me see if I can successfully bring up some of our questions here. Looks like we have 3 or 4. The first one, I'll take these in order, going back to Bosch. On what precedent did the Bosch court rely to reach its decision, or did this court just make new law? If it relied on precedent, can you identify which states for federal circuits? Not to put you on the spot, Jeff, but what do you think? Just generally speaking, I mean, were they citing much in the way of precedent?
Well, they're citing a body of law, basically Illinois state cases and cases from the 7th Circuit Federal Court of Appeals in Chicago to reach that decision. And, I mean, it's kind of I think it's not so much maybe it's a brand new theory, but it's more kind of an expansion. I think you've always had this idea that there's a breach of implied contract out there, but it seemed like in this case that the court was a little bit more loose in saying what you have to do to show and avoid a motion to dismiss and be able to go forward and get discovery and get to a jury or a trial on this type of claim. I mean, the theory itself, I really don't have an issue with that. I mean, it kind of makes sense that if you got a student going through, he's paid his tuition, he's done all the coursework, and school, for whatever reason, some arbitrary action just won't give him his degree or just drops him from the program, you could see how a student would have a beef about that. I think the problem, though, and the difficulty is how do you distinguish between students who have a valid gripe and those who are just making up stuff, and how do you distinguish between the good and the bad cases? And I guess that's a problem we have with a lot of our, any civil lawsuits in the country is that, you've got one side saying one thing and the other side saying another. So in the end, I think the takeaway on this case is just that this theory out there is going to, I think, feed more types of these claims by students throughout the country, basically, where they don't have to tie it to a specific written document or agreement to bring their claim. They're just going to say, this is just unfair what you did to me.
Yeah, which is going to make having established process and following process and having clearly articulated bases upon which to suspend or terminate, clearly stated requirements for maintaining and progressing through the institution, like those technical standards, it's just going to make it more important that schools have all of that articulated so that if a student brings these kinds of claims, that you can proceed and you have that body of documentation and you can proceed to show that the student was appropriately suspended, terminated.
Yeah, less arbitrary and capricious means,
right.
It's all going to be factual, too, as the court says, I got to do something here because I think it's really arbitrary and capricious. The more reasonable the higher ground we have, the standards, technical standards, the less likely this theory is going to be successful.
All right, let's see. Are objectives in a syllabus considered technical standards? I won't say that it would be impossible to cast objectives in a syllabus as technical standards, but really no. I mean, I wouldn't want to have to try to do that, right? I mean, there is this jurisprudence that points to technical standards as a sort of a specific idea, right? These are things that the institutions deliberately determined are any student must be able to perform. Again, they can be physical, emotional, behavioral, professional, but the school said these are the things you're going to have to be able to do in order to successfully complete the program. If it's in a syllabus and it's just one instructor who's put that syllabus together, that doesn't have sort of the same weight of the institution, which is saying we as an academic institution, in conjunction with all of our faculty, have determined that for this program, these are the things that are required for the entire program, not just one class, right? And I think if you're a medical school or a nursing school or any institution, particularly with a clinical component, you're going to want to have these technical standards put together in a thoughtful way, and then you're going to want to have them provided to students in advance and labeled technical standards. By the way, I mean, that is the language used in the jurisprudence, right? And I really like the idea of having them put forth as a disclosure that students sign off on. Sometimes students, may be able to meet those standards when they begin a class, and something happens halfway through, and they can no longer satisfy the standards. They get in an accident, or you never know. And you want to be, and unfortunately, if a student then isn't able to perform, even with accommodation, you need to be able to say, look, these were clearly articulated in advance so that it doesn't look like you're just making stuff up to kick the student out, right? So all of this is to say, it wouldn't be impossible to make that argument, but I don't think you want to play around with this concept. I think if everyone involved in a program ought to sit down and in a very deliberate and thoughtful way articulate what are the technical standards for this program. And there may be overlap. Every program, there may be some related standards, right, that show up repeatedly. Great question. Let's see. Could I get some examples of standards that would be helpful to defeat implied contract claims? Let's see. Can we, for example, say one of our standards is not to swear in a most derogatory way? Like if a student calls another student an improper term. Yeah, well, you can absolutely have standards around professional conduct. And again, I encourage folks, if this is a foreign concept, all you have to do is Google nursing or medical school technical standards, and you will see lots of examples. A lot of public institutions actually have gotten on board with this. There was also a wonderful article in the Journal of College and University Law from 3 or 4 years ago, all about technical standards and specifically in disability matters involving programs with clinical components. It's a lot to chew. It's a pretty long law review style article, but for the attorneys on the phone who don't mind reading that kind of thing, it's very, very good. I think anything that you have around professional conduct is important, right? And articulating this is the level of professional conduct that's required. By the way, technical standards are supposed to tie fairly closely to what are anticipated as standards in the profession that the program may be related to, right? So that may be a little more nebulous for a comparative writing major, right? But for nursing, it's not, right? And you can say, look, if you're going to be out in the field as a nurse, there's an expectation that you will adhere to certain professional standards, and we expect similar standards for anyone moving through our program. And that may mean, and you can look in all these examples, like I said, if you Google, you'll see them, about sort of a level of professional conduct and ability to interact with people in a professional way, et cetera. And when you articulate those things, and then down the road you get a lawsuit around there being some sort of implied contract, you can say, well, look, we make very clear that our students have to satisfy certain professional standards. And that's when you start pulling together affidavits and factual evidence. And you say, this wasn't some sort of irrational or arbitrary or capricious determination. We have these clear standards, and here are facts and reports from our faculty, student, staff that show that this thing happened, so-and-so, attacked this person verbally or called them these inappropriate terms, and that violates our standard, our technical standard, and that was the basis for the dismissal. So I encourage schools in every case, almost regardless of your particular program, I think you ought to have technical standards for every program.
And beyond that, I think the standards themselves, if you're, regardless of the type of program you're offering, can have in there expectations as to student behavior. And the student behavior can be you cannot call your fellow students bad names, you can't threaten violence, you can't do anything like that. And if you do that kind of stuff, then you're going to be kicked out. And the good thing about spelling that out in your policies is that way the student is on fair warning, and they can't come back and say, well, I didn't know I couldn't call my fellow students that. Even though in this day and age you think most students would have enough common sense and wouldn't do that, I still think it doesn't hurt to set it out in your handbook and the standards that are given to the student. And then if the student does break these things, breaches this, it should be documented. That way, if they come back and say, well, I did everything right, you took away you threw me out of the program, you denied me my degree for wrongful reasons, it was arbitrary and capricious, you can come back and say, no, look what you did. We have it documented right here. You, the student, did not comply with the code of conduct that you agreed to when you started our program.
Yeah, and I'm glad you said code of conduct, because I think codes of conduct are valuable and important, but the technical standards are different, right? Code of conduct tends to be about not misbehaving, right? And often a code of conduct will articulate targets of conduct. But often, too, it will sort of prohibit certain types of conduct. And the technical standards are a little different, right? They're a little vaguer. They'll say something like, you're expected to comport yourself in a professional and meaningful way, and you have to have the ability to interact, with other students and faculty and staff. And I like that because it's a broader, often they are phrased in a way that's a little broader than codes of conduct, which will say, you have to wear these kinds of clothes but both are valuable. And in this day and age where students, I think, are bringing more lawsuits and courts are more willing to look at them and more willing to look at your documents and what you do have in writing as either actual contracts or creating some sort of implied contract, schools want to take the time to make sure that you want your code of conduct, your technical standards to be well articulated and thoughtful. But the other thing, too, is somewhere in your documentation, you want to make clear, if not on the face of the code of conduct and the technical standards, elsewhere, you want to articulate what are the bases for suspending or terminating a student. And a failure to comply with the code of conduct or the technical standards should be clearly stated as a basis for suspended or terminating somebody, right? And so that way it all sort of ties together, in addition to, not paying your student account in full or something like that. All right, let's see. We have one more question. In Palladino, does the return of the parent's tuition money to the college also address parent loans? So I think the idea there is, what if those payments had been made not in cash, but what if those had been like plus loans, parent plus loans that have been used to make the payment?
Well, in that case, the federal government is making the money. The parent is on the hook for the loan, trying to invalidate the loan. That's a good question. Honestly, I don't know the answer to that. That would be a novel issue. The parent is effectively providing their credit and to obtain the loan, and then the loan's being used to pay for the student education. That's an excellent question.
Well, and in my mind, it's not in that case, the parent, the issue in that case was the court was trying to recover money that the parents had paid. So those were assets of the parents, right? That the court was trying to recover for the benefit of the creditors. The assets, if it's a loan that's made, the asset that was provided to the institution was not an asset of the parent. It was actually an asset of the U.S. Department of Education, right? So in that case, I don't know why a bankruptcy court would have the ability to say that money has to come back from the institution, because the money doesn't belong to the parents. It belongs to the U.S. Department of Ed. So it's not going to benefit creditors. It would be a court forcing the school to execute on a return of Title IV to the department, and I'm not sure why that matters to the bankruptcy court, because at no point are those assets of the parents. So
that's an excellent point, Aaron. I believe you're right on that.
So it's an interesting question, and my gut is in this case that if they were Title IV federal loans in the form of plus loans, that it wouldn't come into play, because the court would just say, well, that was never yours in the first place. Which means, I think that if the school actually provided the education, the student was eligible for Title IV and earned those funds, then in that case, that the school gets to keep the funds. Now, the U.S. Department of Ed is going to become an unsecured creditor against the parents in their bankruptcy proceeding, because the parents owe the department. But in that case, the department's just another creditor. So I think that's how it would all work. But we are shooting from the hip here, so it's something to think about at a little more length. Hey, I speaking strictly for myself here, I have thoroughly enjoyed this. I find this extremely interesting. There's so many court cases out there, and for me, this kind of conversation and thinking through some of what is in play, particularly the recent stuff, is useful, and as an attorney type, fascinating. I'll just ask again, if you like this format, it's something we were thinking about doing, sort of curating cases on a semi-regular basis. Please, in the survey, let us know. And I bet I think I can probably twist the arms of Jeff and Bill and get them to do something like this on a more regular basis. Otherwise, hope everybody's well. Have a great day, and don't forget to look out for our immigration webinar that's coming up just a couple of weeks out with our partner Kelly Simon. Have a good one, everybody, and we'll see you soon.